Please be seated and maintain silence. Good morning, the panel judges, ladies and gentlemen. May it please the court. On behalf of the organizing committee of the Dayanand Law National Level Moot Court Competition 2026, it is my honor to introduce the learned members of the bench presiding over this preliminary as well as final rounds. We are privileged to have with us Honorable R.Y. Sheikh Sir, former Principal District Judge, who has had a distinguished career spanning over 45 years in the field of law as a professor, an advocate, and as a judge. We are also honored to have the presence of Advocate Shaileshji Chappalgaonkar Sir, distinguished advocate practicing at High Court of Bombay, bench at Sambhajinagar. Whose contribution to the legal practice are widely recognized. Thirdly, we have with us Dr. Bhavna Kadu, a distinguished legal mind and an assistant professor at School of Law, MIT Pune. The organizing committee is deeply grateful to the learned judges to taking time out of their demanding schedule to guide, assess, and encourage the participating teams. With your lordship's permission, we shall now proceed with the round. Thank you.
क्या सीरियल की है इस टीम का क्या सीरियल है क्या पेपर लगा नहीं पेज नंबर ठीक है लेकिन नेम अच्छा जी 25, 26, हाँ हाँ तो ये तो क्राइटेरिया ठीक है हाँ इसमें काउंसिल 1 और 2 अच्छा अच्छा 25 27
May I please, Your Honorable Court? I am the plaintiff on behalf of the counsel is here in the matter of Samira Kiran Khanna versus Prisha Khanna on behalf of the plaintiff Samira and Kiran. With the due permission, I am the counsel number 1. I am dealing with the first 3 issues and my co-counsel will deal with further issues and prayer. With the due permission, I would state the facts. My lord, the Sanjeev Khanna was the multinational industrialist from the Union of India and he was married with famous actress Kajal Khanna in 2003. and from whom they have two children named Samira and Kiran. After few years, in 2016, both get separated, and Sanjeev Khanna married with her friend Prisha Senegal, and from whom they have one son. The name is Azhar. In 12 June 2025, Sanjeev Khanna dies while playing polo in United Kingdom, and after that, Sanjeev's death, the first wife Kajal Khanna and her children met the Prisha Senegal, the second wife of the deceased Sanjeev Khanna. And at that time, the Prisha claimed that Sanjeev had left no will, and his entirely estate housed under the SK Family Trust. Then the families, their advisors, along with the Shruti Suri Malhotra, the executor of the Sanjeev Khanna estate, meet at the Arauli on 30 July 2025. And at this meeting, the Kajal and her children saw the deceased Sanjeev Khanna will on dated 21st March 2025 for the first time. This will leaves all his personal estate to Prisha, making her sole beneficiary. But the first wife and children, as well as the Renu Khanna, the mother of deceased Sanjeev Khanna, have questioned on its authenticity. And they have alleged that the will is forged and fabricated, and signatures on it are not Sanjeev Khanna, but the allegedly forged by Prisha with the collusion of two witnesses. Early September 2025, the disputes escalated in a former civil suit in the High Court of Arauli, where the Samira and Kiran sought to declare the will void and demand for the forensic examination of the original document, while Renu Khanna claimed she was forced into signing on menstrual documents without her will. In response, Prisha Senegal Khanna sought to file the asset list under a sealed cover with the non-disclosure agreement to prevent media trial, a request court found problematic. If the Honorable Court is satisfied with the statements of facts, may I start with the statements of issues? My Lord, the issue number 1 is whether purported will dated 21st March 2025 was validly executed and attested as per Section 63 of the Indian Succession Act 1925, whether the will has been duly proved in accordance with Section 68 to 71 of the Indian Evidence Act. My Lord, the plaintiff submit that the will was not validly executed according to the rules prescribed under Section 63C of the Indian Succession Act 1925, which requires that testator must sign in the presence of the witnesses. The affidavit of the first witnesses, Shruti Suri Malhotra, provide direct evidence of procedural failure, my Lord. She explicitly admits that I left shortly before the signing was complete and cannot confirm if the both witnesses are signed in the presence of testator, that is Sanjeev Khanna. For a will to be validly executed, the witnesses must either see the sign or receive a personal acknowledgement of a testator. But Malhotra's own admission, my Lord, that she left before the process was complete creates a legal void. Hence, there is a fatal non-compliance with the Section 63 of the Indian Succession Act. My Lord, in a Janaki Narayan Bhuir versus Narayan Namdev Kadam, the Supreme Court stated that if an attesting witness does not prove that the other witness also signed in the presence of a testator, the requirements of Section 63C are not met. My Lord, Malhotra's inability to confirm the signature, second signature, is a fatal under this principle. Then, my Lord, there is a failure to discharge the burden of proof under the Indian Evidence Act. The burden of proving the due execution of the will lies squarely on the propounder, that is the defendant. The plaintiff argues that the burden cannot be discharged under Section 68 to 71 of the Indian Evidence Act. Under 68, at least one attesting witness must be examined to prove execution. However, Malhotra's own affidavit undermines the defendant case by confirming that the document was not read aloud in her presence. and that she cannot verify the finality of the signatures, since the primary witnesses cannot confirm the statutory provisions of simultaneous presence. Hence, the execution remains unproved. And my lord, there is a unexplained suspicious circumstances, because a will is not proved merely by the proving the signatures. The propounder must satisfy the judicial conscience by removing all suspicious circumstances surrounding its creation. The will entirely disinherits the deceased children's and as well as the mother Renu Khanna. The highly improbable, because the deceased mother and children, the deceased maintain a regular and loving relationship with them, and even taking them on trip to Maldives before the death. And the following date, on 12 June 2025, the defendant initially claimed that Sanjeev had left no will, and the sudden emergence of will on 30 July 2025 that grants her total control over 30,000 crore estate is a badge of fraud, my lord. And there is a Renu Khanna on record stated that she was made to forced to sign on a certain mystery documents without her will, and there is a coercion, my lord. If the Honorable Court is satisfied with the issue number 1, with the due permission, I will start with the issue number 2. Much up. My lord, issue number 2 is whether the plaintiff have discharged the burden of proving that the purported will is a forged, fabricated, or obtained by fraud or under influence. Whether such acts, if proved, attracts criminal liability under section 467 of the Indian Penal Code 1860, and whether a civil court can direct a parallel criminal investigation. My lord, plaintiff contend that the purported will surrounded by the badges of fraud. As previously stated, my lord, the will entirely disinherits the deceased children and as well as the mother. And the deceased maintain a regular loving relationship with them, even taking on them trip to Maldives shortly. And it is highly improbable and unnatural for the father to leave his children entirely without provisions. And there is a allegation of coercion by the mother Renu Khanna. My lord, there is a evidence, digital forgery and asset dissipation. The plaintiff rely on specific financial irregularities to prove pattern of fraudulent activity. The Zenith Bank statement shows a transfer of 15 crore to the defendant on 6 May 2025. The plaintiff alleged that the signature was digitally forged and that the transfer was actually posthumous, because the immediately following the date, account was wiped out and showed dormant with zero balance. This suggests an urgent attempt to siphon the assets and before the probate process could be initiated. Hence, my lord, there is a criminal liability under the section 467 of the Indian Penal Code. My lord, under section 467, forgery of a will is a non-bailable and serious offense. The plaintiff alleged that the respondent, in collusion with the other attesting witnesses, created a false document to gain control over valuable asset, 30,000 crore, given a specific allegation of digital forgery. And also, my lord, the civil court has power to direct a concurrent criminal investigation. In a case of high-stake fraud involving class 1 minor heirs, a civil court has power to direct a criminal investigation to uncover the extent of conspiracy. The jurisdiction of High Court has power to trial as civil as well as criminal case, and the jurisdiction of High Court can give both the remedies in same case because it is a not specific civil or criminal appeal case. This is the original civil jurisdiction of High Court under the Article 226. In Niranjan Umeshchandran Joshi versus Mridula Jyoti Rao, the court held that the presence of multiple suspicious circumstances like unnatural disposition of assets, shaky witnesses can lead to the conclusion that the will is a fabricated document. If the Honorable Court is satisfied with the issue number 2, may I start with the issue number 3? Issue number?
Repeat issue number 2 again.
you said about the jurisdiction of the High Court? What you have just said about the jurisdiction of the High Court, repeat that.
The plaintiff have approached the Honorable Court of Arauli under its original civil jurisdiction to seek a declaration regarding the validity of purported will and distribution of asset of the late M.R. Sanjeev Khanna, Mr. Sanjeev Khanna. Issue number Article 2.
What is the reference to that?
My lord, a petition for inherent rights in a high court where the pecuniary jurisdiction exceeds 2 crore is generally filed under the original civil jurisdiction of high court under Article 226.
You sure? Article 226.
As per my lord,
As per?
as per my knowledge, my lord, counsel is
Different.
I'm
Whether
not-
it is applicable in this case,
Article 226 is applicable in this case.
no, my lord.
then
You are referring about this Article 226 for the jurisdiction.
You have Constitution in your hand.
Yes, ma'am.
Read, please.
So read jurisdiction, Article 226.
How you are fitting your suit in read jurisdiction?
Counsel is department.
There is a original jurisdiction vested with the High Court, Bombay, but not under Article 226.
Yes, ma'am.
Okay?
Counsel is
It's a suit in all sense, right?
Yes,
Not under Article 226. Just remember that. Yes, carry on.
My lord, issue number 3 is whether the honorable court can receive the alleged bill and related documents in seal cover and impose confidentiality conditions or non-disclosure agreements, whether a such seal cover proceeding violate the principle of open justice, public interest and freedom of the press. My lord, there is a violation of the principle of open justice. The plaintiff argued that the High Court decision to allow filing a statement of asset in a seal cover, even in an interim stage, undermines the fundamental legal maxim that the justice must not only be done, must be seen to done. Transparency is essential to prevent the concealment of dissipated assets, given that the plaintiff have already alleged that the certain bank accounts are wiped out following the date of the testator. Shielding that asset list is a public and party scrutiny facilitate potential impropriety. This case involves the multinational industrialists and massive estate attracting significant public interest. Restraining information through seal covers violate the rights of the free press to report on judicial proceeding accurately as noted in the media extracts. My lord, there is an absence of legal basis for non-disclosure agreements. The plaintiffs strongly support the court's observation that the defendant request to compel counsel to sign in on non-disclosure agreement is a problematic and without legal basis. Compelling legal practitioners in a sign on non-disclosure agreement restrict the ability to communicate freely with their clients and undermines the advocate-client relationship. While the court can ensure confidentiality through judicial orders, example, marking documents confidential for a legal use only, it cannot force a private contract upon officers of the courts as a prerequisite for a practicing law. And my lord, under Indian Evidence Act, the plaintiff have a right to inspect the evidence used against them. A seal cover procedure denies the plaintiff the ability to effectively change the provisions and accuracy of the financial disclosures. If the Honorable Court is satisfied with the issue number 3, my co-counsel will deal with the further issues. Much appreciated.
May I please the Honorable Court? I am the counsel on behalf of plaintiff. Speaker number 2, if the Honorable Court permits, I would like to proceed with further issues. Much obliged, Your Honor. The issue number 4 is that the interim relief and preservation of assets, whether the plaintiffs are entitled to interim reliefs, including freezing orders, injunction under Order 39 of CPC, appointment of a receiver, and disclosure of bank or demat accounts, whether the plaintiffs have satisfied the test of prima facie case, balance of convenience, and irreparable injury. Your Lordships, the plaintiffs are entitled to immediate interim relief, including the freezing orders and the appointment of a receiver to prevent the further dissipation of the late Sanjeev Khanna's 30,000 crore of estate. This request satisfies the threefold test required under Order 39 of the CPC. Your Lordship, there is the establishment of a prima facie case. A strong case exists based on a suspicious circumstances and defective execution. The respondent's initial claim that the deceased has left no will between 14 and 17 June of 2025 directly contradicts the sudden production of the will on 30 July 2025. Your Lordships, furthermore, according to the Annexure B, that is the affidavit of Shruti Suri Malhotra, she explicitly stated and admitted that she left shortly before the signing was complete and cannot confirm that both the witnesses had signed in the presence of the testator. Your Lordship, this constitutes a fatal violation of Section 63 of the Indiana Succession Act. There is the irreparable injury that unless assets are frozen, the plaintiffs will suffer the injury that money cannot alone compensate the plaintiffs. According to the Annexure C, that is the bank account statement, Zenith Bank records show a rupees 15 crore transfer made to the respondent on 6 May 2025, which the plaintiffs allege was a posthumous digital forgery. Accounts are being actively wiped out and shown as the dormant or transferred with a zero balance. Your Lordship, the balance of convenience tilts heavily towards the minor plaintiffs, who are the class 1 heirs, and the judicial intervention is necessary to ensure the estate remains intact until the will's authenticity is forensically determined, and especially since the respondent has already registered beneficiary ownership for her own son while excluding the plaintiffs. In the case of Dalpat Kumar versus Prahlad Singh, this case is...
Within 1 minute you can.
Okay.
Let's go through the prayer first.
What
Issue.
is your
With the
prayer?
issue,
No, 2 more issues are remaining.
your time is already over. Directly come to the prayers.
Okay. Wherefore, in the light of the facts and argument presented, the plaintiffs respectfully pray that this honorable court be pleased to declare the purported bill dated 21st March 2025 as null and void, issue a permanent injunction restraining the defendants from dealing with or disposing of the assets, direct a concurrent criminal investigation and forensic examination of the signatures, and declare that the plaintiffs are entitled to their lawful share of the estate under the law of intestacy, and pass any other order that this honorable court may deem fit in the interest of justice, equity, and good conscience. For this act of kindness, the plaintiff shall forever pray. Sorry, Your Worship?
Forensic.
Is your final prayer?
The final prayer is that the declare the purported will as
That we
one.
understand, but okay, what are your interim prayers?
Interim prayer.
Yes.
Interim prayer is the give the permanent injunction restraining the defendants from dealing with
Alright,
or
next.
disposing of the assets,
Next.
and direct a concurrent criminal investigation and a forensic examination for the signature, and declare the plaintiffs as plaintiffs are entitled to their lawful share of the estate under the laws of intestacy. If the honorable court is satisfied with the issues and prayer, much obliged. May it please your lordship. May it please your lordship, the council seeks permission to address the bench individually as your lordship and your ladyship, and collectively as your lordships. Much obliged, your lordships. The council, team number 33, is appearing on behalf of the defendants in the case of Samira Khanna and Kiran Khanna, appearing through next friend Mrs. Kajol Khanna versus Mrs. Prisha Khanna and
Bench
others.
is already aware about the facts. You can directly come to the issues.
Much obliged, your lordships. I am the co-counsel. I am the counsel number, speaker number 2. I will be dealing with the issues 1, 2, and 3. And my co-counsel, speaker number 1, will be dealing with issues 4, 5, and 6 respectively. Your lordships, shall I proceed with the submissions on issue number 1? Much obliged, your lordships. Your lordships, the central question before this Honorable High Court is not whether the plaintiffs are sympathetic claimants. The real question is, can a validly executed will be displaced by conjecture, dissatisfaction, and speculative allegations without trial and without proof? The defendants submit respectfully that it cannot. Your lordships, it is a settled proposition that a person of a sound mind can has the absolute freedom to dispose of his property through will, and the courts do not sit in trials just over the testator's choice. As held in Pentakota Satyanarayanan versus Pentakota Sitharatnan in the year 2005, the Honorable Supreme Court held, and I quote, "A testator has the freedom to dispose of his property in any manner he chooses." I unquote. Thus, your lordships, mere dissatisfaction with of the yes with the distribution of the property cannot invalidate a will in this present case. Further,
What about the ancestral property?
yes, your lordships.
This is a self-acquired property or ancestral property?
Your lordships, Mrs. Renu Khanna. Your lordships, most of the property is also the part of the property is also self-acquired.
Self-acquired property.
Part of the property, yes, your lordships.
Does probate declare all these things?
What, your lordship?
What do you mean by probate?
Disputed will, your lordships.
Sorry?
Disputed will.
Okay, you continue.
Much. Yes, your lordships. Shall I continue? Your lordships, Indian law is unequivocal that inheritance per se is not a suspicious circumstance. As held in Rabindranath Mukherjee versus Panchanan Banerjee in the year 1995, the Honorable Supreme Court held, and I quote, "The whole idea behind the execution of a will is to interfere with the normal line of succession. So naturally, natural heirs would be debarred in every case of the will." I unquote. Thus, the plaintiff's reliance on exclusion alone is legally insufficient in this present case. Furthermore, your lordships, the will expressly requires that family trusts were constituted in 2018 for the benefit of the plaintiffs, and this provides a legitimate and rational basis for the exclusion from the will. As held in Mahesh Kumar versus Vinod Kumar in the year 2012, the Honorable Supreme Court observed, and I quote, "Where reasons for the exclusion are apparent on the face of the will, suspicion stands mitigated." I unquote. Thus, the will cannot be branded as unnatural in this present case. Your lordships, furthermore, Section 63 of the Indiana Succession Act requires substantial compliance and not hyper-technical perfection. The affidavit at Annexure B confirms presence during the execution, and inability to confirm minute details does not negate this attestation. Furthermore, once execution and attestation are prima facie established, the onus shifts to the challenger. As held in Shri Devi versus Jairaj Shetty in the year 2005, the Honorable Supreme Court held, and I quote, "In case the person contesting the will alleges undue influence, fraud, or coercion, the onus will be on him to prove the same." I unquote. Thus, the plaintiffs have failed to discharge this burden. Furthermore, the ultimate test of the validity of the will is whether the court's conscience is satisfied. In the case of Shashi Kumar Banerjee versus Subodh Kumar Banerjee in the year 1964, the Honorable Supreme Court held, and I quote, "A will duly executed and attested must ordinarily be upheld unless suspicion circumstances are clearly established." I unquote. And your lordships, no such clear suspicion circumstances exist in this present case. If your lordships are satisfied with the submissions on issue number 1, shall I proceed with issue number 2? Much obliged, your lordships. Your lordships, forgery and fraud are serious allegations requiring strict proof. As held in AC
When the
Anand.
succession certificate was issued?
Your Lordships, the corporate filings said the ownership in favor of the Mrs. Prisha Khanna and her child and her son, Ajar Khanna.
Whether the court has issued the succession certificate in this case?
No, Your Lordship. May I proceed, Your Lordships? Much obliged. As I continuing, Your Lordships, in Ananthaswamy, AC Ananthaswamy versus Boraya in the year 2004, the Honorable Supreme Court held, and I quote, "Forgery is a question of fact and must be pleaded with particulars and proved by evidence." I unquote. The plaintiffs rely on conjecture here and not evidence. Furthermore, courts do not order forensic examination merely because a document is disputed. Expert evidence cannot be sought as a matter of course without laying foundational facts, and the plaintiffs here have failed to establish these foundational facts. Furthermore, the will was disclosed in July 2025, and
But
yet
just due to this reason, it is not affecting the other party right? If
Your
you are
Lo-
not allowing, if you are not allowing the examination of the same, then it is not allowing the other party right? It is not violating the other party right?
Your Lordships, in this present case, there's a dispute because they have failed to establish the foundational facts, as I just said, and it is not. It is a The case involves a lot of property. The estate values around 30,000 crore rupees, so it affects the third-party interest as well, and that's why we ask for.
You proceed.
Much obliged, Your Lordships. The will was disclosed in July 2025, and yet no immediate forensic examination was made. The delay in challenging the will also is a relevant consequence in assessing its genuineness. Furthermore, the section 467 of the Indiana Penal Code says that consequences arise only after criminal adjudication. Civil proceedings should not be stayed or converted merely because a criminal liability is alleged. In the case of Ramdev Food Products Private Limited versus the state of Gujarat, in the year 2015, the Honorable Court held, and I quote, "The process of criminal law cannot be used when a dispute is primarily of civil nature. Simultaneously, initiation of criminal proceedings may be permitted where an offense is proved to have been committed." I unquote. Your Lordships, the plaintiff's attempt to import criminality is not sufficient here. Furthermore, premature forensic orders risk irreparable harm during the state governance and third-party interests. As held in Thiruvanda Pillai versus Navneet Thammal in the year 2008, the Honorable Supreme Court held, and I quote, "Courts must exercise caution before ordering scientific tests affecting the civil rights." Thus, Your Lordships, allegations of forgery and undue influence are bald, speculative, and they do not warrant forensic examination. With Your Lordship's permission, shall I proceed with the submissions on issue 3? Much obliged, Your Lordships. Your Lordships, open justice is not absolute. In Naresh Sridhar Mirajkar versus the state of Maharashtra in the year 1967, the Honorable Supreme Court held, and I quote, "Open justice is subject to exceptions where administration of justice so demands. Furthermore, the right to privacy may justify limited departure from open court proceedings." I would like to draw your attention towards the case of K.S. Puttaswamy versus the Union of India, where the Honorable Supreme Court held in 2017, the balance between transparency and confidentiality is a very delicate one. And if some sensitive information about a particular person is made public, it can have a far-reaching effect on his or her reputation and dignity. The right to know is not a fundamental right, but at best it is an implicit fundamental right, which is hedged in with the implicit fundamental right to privacy, which all people enjoy. And thus, Your Lordships, the present case involves 30,000 crore rupees worth of assets and third-party interests as well. And the Annexure D permits non-disclosure agreements, but it also gives the plaintiffs' counsels the permission under confidentiality. In Sahara India Real Estate Corporation versus SEBI in the year 2012, the Honorable Court held, and I quote, "Courts may regulate dissemination of sensitive information to prevent trial by media." I unquote. And Your Lordships, the defendant sought non-disclosure agreements to prevent the misuse of data. Confidentiality safeguards may be imposed to balancing comparing interests. If your lordships are satisfied with the submissions on these issues, I would like to call my co-counsel to deal with further issues. Much obliged, your lordships.
May it please Your Honour, the Council seeks permission to address the bench collectively as Your Lordships and individually as Your Ladyship and Lordship. Much obliged, Your Lordship. Your Lordship, I am Counsel number 2 and I will be dealing with issue number 3, 4 and 5 4, 5, 6 respectively. With the Lordship permission, may I proceed with the submission on issue number 4? Much obliged, Your Lordship. Your Lordship, the interim relief is preventive and discretionary, not automatic. It exists to protect the judicial process and to not to punish the party or to suspend the lawful right. Your Lordship, the settled position of law was laid down by the Honorable Supreme Court in the case of Dalpat Kumar versus Prahlad Singh in the year 1993, where the court held, and I quote, that an interim injunction can be granted only when the 3 conditions are satisfied, namely prima facie case, balance of convenience, and third is the irreparable injury. Your Lordship, I submit that the plaintiff fails on all the 3 counts. Firstly, there is no prima facie. The plaintiff's entire case at this stage rests on the allegations of the forgery. These allegations are seriously disputed and cannot be decided without a full trial. Your Lordship, in Zenith Matlas versus State of Maharashtra, the Honorable Supreme Court in the year 2009 held that the court must not conduct a mini trial while deciding an interim applications. Disputed questions of the fact must be left for the adjudication. Your Lordship, in the present case, a will is a subsisting testamentary document. Until it is judicially set aside, it continues to operate in the eye of the law. Your Lordship, therefore, no prima facie right exists in the favor of the petitioners. Your Lordship, the next requirement is the balance of convenience. In Adhunik Steel versus Orissa Manganese case, the Honorable Supreme Court in the year 2007 held that the court must consider the real and the practical consequences of an interim order. Your Lordship, here granting an interim order would freeze the rights flowing from a valid will, disrupt the administration of the estate, and potentially affect the third parties who are not before this Honorable High Court. Therefore, Your Lordship, this will effectively prejudice the validity of a valid will at an interlocutory stage. Your Lordship, on the other hand, if the interim relief is refused, the plaintiffs suffer no harm. Their claims can be fully addressed after the trial, thus if they succeed. Your Lordship, here the balance of convenience clearly lies in the favor of the defendant. Your Lordship, finally the third requirement is there is no irreparable injury. Your Lordship, as held in Adhunik Steel, where monetary compensation is an adequate remedy, injunction should not be granted. Your Lordship, this is a proprietary dispute. Even assuming that the petitioners succeed eventually, the law is capable of compensating them. A mere apprehension that the property may be dealt with does not amount to an irreparable harm. With the Lordship permission, may I proceed with the submission on issue number 5? Much obliged, Your Lordships. Your Lordship, Order 32 of the CPC is meant to protect the minors, not to expose them to the conflicted litigations. Your Lordship, in Ramchandra Arya versus Mansingh, the Honorable Supreme Court held that a person having an adverse or potentially adverse interest is disqualified from acting as a next friend. Here, Your Lordship, the mother of the minor is not acting in purely representative capacity. She is independently asserting the claims over the estate and seeks invalidation of the will in the manner that would directly advance her own interest. Your Lordship, this creates a clear conflict of interest, rendering her representation legally impermissible. Further, Your Lordship, in Naiga versus Chaudhama, the Honorable Supreme Court emphasized that the court must exercise strict scrutiny while allowing the representations of the minor to ensure that the interests are not compromised. Your Lordship, Order 32 of the CPC does not mandate the mechanical acceptance of any person claiming to act as the next friend. The court has the duty of vigilance, so while the welfare of the minor is paramount, it cannot be used to bypass the statutory safeguards. Your Lordship, in the Rosie Jacob versus Jacob Chakramakal, the Honorable Supreme Court held that the court acts as a parent's patron, particularly where the minor's property is involved and must guard against the conflicted representation. Your Lordship, therefore, is independent or court supervised representation as explicitly permitted under Order 32 of the CPC. With the Lordship permission, may I proceed with the submission on issue number 6? Much obliged, Your Lordships. Yes, Your Lordship. Your Lordship, the relief must flow from the adjudicated rights, not from the allegations. The plaintiff's prayer proceeds on the presumption that the will is invalid. That directly contradicts the settled law that the will remains operative until it is set aside. Your Lordship, here a declaration of intestacy is a consequential relief. It arises only after the will is conclusively held to be invalid. Where a will is propounded under the adjudication, the scheme of the intestate succession does not automatically apply. Your Lordship, granting such relief at this stage would amount to a granting final relief without a full trial, and it is impermissible. Secondly, Your Lordship, directions for the renderation of the accounts or transfer of the asset presuppose wrongful possession. Such reliefs are consequential and cannot prejudice the adjudication. Further, Your Lordship, criminal proceedings cannot be used as a pressure tactic to serve civil reliefs. The testamentary dispute must be resolved. With the Lordship permission, may I proceed with the prayer? Much obliged, Your Lordship.
Whether you feel that injustice has been caused on other side in this matter by way of this will, whether injustice is caused on other side, particularly on son.
No, Your Lordship. The will itself states that a trust has been made in the name of them. Please refer to the Annexure A. Your Lordship, the para 3 says that I have already constituted 2 family trusts in 2018 for the benefit of my children, Samira Khanna and Kiran Khanna, and therefore no further provisions shall be made for them in this will. This states that they are not been excluded from the property. They have been given something for their future.
What about mother?
Your Lordship, it is not an ancestral property, so it is solely his decision whether to give the property to mother or whether he have to give something to his family or others, members. Whatever he thinks, he will give to them, whatever he feels right. And being Prisha the one who is residing with them, and they has the close bond, so he will most probably he will give his property to her only, as she was the one who was staying with him and the lovable person. May I proceed with the prayer, Your Lordships? Much obliged, Your Lordship. In the view of the facts and the circumstances of the present case, the issues raised, submissions and the authorities relied upon, it is most respectfully prayed at this Honorable High Court of Aravali may be pleased to first, dismiss the plaintiff's challenge of the will dated 21st March 2025. Second is to uphold the validity of will. Third, to reject the prayer of the forensic examination. Fourth, to continue the sealed cover confidentiality with safeguard. Fifth is to decline the interim injunctions and pass any other order in the interest of the justice, equity, good conscience, all of which is most humbly prayed.
Now answer to one thing, why during the pendency of the suit you should not be restrained from disposing of the property or spending all the money or creating third party interest over the suit property?
Your Lordship, can you please repeat the question?
Why you should not be restrained from disposing of the property or creating third party interest over the suit property or spending of the amount in the account? Why the account should not be sealed? Answer this.
Your Lordship, the account, the transfer which has been made is on behalf or is for the Prisha Sehgal. Your Lordship, defendant number 1. She don't have any other source of income. So if we seal the account, how she will do?
Issue to be decided finally.
Yes, Your Lordship.
Yes, then during the pendency of the suit, what we should do? We should protect their interest also.
Your Lordship, their interest is being already protected.
How?
Your Lordship, till now, they didn't even thought of saying that we don't have anything to survive. We don't have anything for the livelihood. We can consider that they have the things for their livelihood. But what about the defendant number 1? How she will survive? How their livelihood will be
Let the
possible?
court decide that. Let the court decide that.
Yes, Your Lordship.
Then, what is your answer? We should protect their interest.
Your Lordship, their interest is being protected,
How?
but the will is not fabricated or forged. Your Lordship, the trust has been made in their name in 2018. And already they have been living with their mother since childhood.
Okay. Okay, fine. Thank you.
Thank you, Your Lordship.
1 minute.
Your Lordship, the plaintiffs have, defendants have misquoted that the property is not ancestral. I would like to clear that the facts itself states that the property is inherent from the father of Sanjeev Khanna.
The succession certificate is issued in this case?
No.
Have you received the succession certificate?
No. The certificate is not issued here.
What are the proofs that are submitted that the property is ancestral?
The Renu Khanna itself stated that in the facts that the property is inherent from his father of Sanjeev Khanna.
All property.
The part of the property.
Have you calculated that?
No, Your Lordship.
You proceed.
Thank you.
Whether you want to give any answer? How reply to reply? How
Yeah.
you are allowed to give reply again?
Sir,
After hearing their argument, you have answered.
Your Lordship,
Accordingly, how you can get
we
again?
have the following procedure for the sir rebuttal, so that's why I just came to address their rebuttals question.
This is unending.
Your,
This is unending.
sorry, Your Lordship.
This will be unending. We satisfied with whatever the discussion we
Sure,
have
Your Lordship.
already.
Thank you.
have.
Thank you.
I am counsel appearing on behalf of appellant. Can I proceed? Obliged. First facts. Sanjeev Khanna, an industrialist, died on June 12, 2025.
Excuse me, we know the facts. Now go on with your submissions.
Sir, I will proceed to issues.
On whose behalf you are appearing?
Appellant side.
Appearing for whom? He's asking.
Kiran Khanna and Kiran
What is their designation?
yes sir, I don't understand.
What is their designation? Whether they are appellant,
Yes,
or applicant, or plaintiff?
appellant sir.
Appellant. Are you sure?
Yes sir.
Proceed.
Can I proceed, sir? Issue number first, execution and attestation of a will. The purported will dated on 21st March 2025 has not been proved in accordance with law. My lord, the burden of proving a will entirely lies on propounder, not on the challenger. As per section 63 of Indian Succession Act and section 68 of Indian Evidence Act, the will must be executed by a testator and attested by two witnesses in his presence. In the present case, the attesting witness herself admits that she left before the execution was complete, and Therefore, they cannot confirm joint attestation. That is a fatal blow of statutory compliance. As per case H. Venkatachala Iyengar versus B. N. Themma Jemma, AIR 1959, Supreme Court case 443, the court held that the proof of a will requires satisfaction of suspicious circumstances, judicial conscience, not just formal compliance. Since the attestation is fragmented, that standard is not met here. Facts of the case. This case is Supreme Court deals with will, where the propounder took the prominent part in the execution and received substantial benefit. The court held that when the signature of a testator is shaky or disposition seems improbable, the propounder must remove the legitimate doubts before the will is accepted. If court is satisfied with issue number 1, the council will now proceed issue number 2. Can I proceed? Oblige, sir. Issue number 2, existence of suspicious circumstances. Even if formal proof is assumed, the will is surrounded by grave suspicious circumstances. My lord, the court must examine the surrounding circumstances. Firstly, the will completely disinherits 2 minor children. Secondly, it excludes the testator mother. Thirdly, it confers the benefit and control upon the respondent. Fourthly, the document emerged only a dispute arose. As per case law, Bharpur Singh versus Shamsher Singh, 2009, 3, Supreme Court case 687. The court held that unnatural exclusion of a legal heir constitute strong suspicious circumstances. If these doubts remain unexplained, the propounder, the will must be set aside. Case facts. The court identified that a will may be held suspicious if it excludes the natural heirs without a sufficient reason. If in Bharpur Singh, the court noted that the propounder was position of dominant, the will of a testator, the burden shift heavily on them. Another case in Jaswant Kaur versus Amrit Kaur, 1977. Fact of the case, the court held that if a will prepared under circumstances which raise the suspicious of the court, it is for propounder to adduce evidence to remove the suspicion. It especially pointed to case where the propounder benefit the cause of the natural heirs. If the court is satisfied with issue number 2, counsel move towards on issue number 3. Oblige, sir. Issue number 3, fraud and financial manipulation. The will is result of fraud and manipulation. Bank records reveal even transaction alleged made after the death of testator. It is a settled principle that fraud vitiates even the most solemn transaction. As per case law, S.R. Srinivasa versus Padmavathamma, 2010, 5, Supreme Court case 274. The court held that when fraud is alleged with supporting material, the court must adopt strict scrutiny. Here, the strict scrutiny demolished the respondent case. My lord, counsel number 1 has addressed the above issue. Now, counsel number 2 has addressed the remaining issues. Oblige.
My lord, my counsel has addressed the above issues and I will address the remaining issues. If the court is satisfied with the issue number 3, the counsel will now proceed to issue number 4. Oblige. Issue number 4, open justice versus seal covers. The issue of seal covers and NDS undermine a fair trial. The respondent seeks to hide behind NDS seal filings. The respondent seeks to hide behind NDS seal filings. Case law. In Swapnil Tripathi versus Supreme Court of India, 2018, 10 SCC 639. The Honorable Court reaffirmed that open justice is a constitutional principle. Seal covers violates Article 21 by preventing effective rebuttal. Secrecy cannot be justifies a private inheritance dispute. Case fact: this case challenged the lack of transparency in judicial proceeding, leading the court declare the open justice is a part to right of know and the right to fair trial under Article 21. The case has been referred from the defendant memorial, which constitute relevant case facts, legal issues and supporting information. May it please this Honorable Court, in addition to the other authorities rely upon, I respectfully place reliance on the judgment of the Supreme Court of India, Nigaya versus Chavadama, 2009-14, SCC 770. My Lord, in that case, the Honorable Court clear held that mere possession or mutation interest do not confer ownership of immovable property. A valid legal transfer is necessary, and if no lawful transfer is proved, the property develops upon the legal fares. This principle directly supports my submission that the defendant, having failed to prove a valid transfer, cannot claim title over the property. If the court is satisfied with issue number 4, the counsel will now proceed to issue number 5. Issue number 5, protection of the estate and interstate succession. The appellant are entitled to interim protection of the estate. The appellant is threefold test laid down in Dalpat Kumar versus Prahlad Singh, 1992, 1 SCC 790. Case fact: the Supreme Court clarifies that prima facie case does not mean a certainty of winning, but a serious question to be tried. It emphasizes that irreparable injury is one that cannot be compensated by money. Firstly, prima facie case, an unproved and unsuspicious will. Secondly, balance of convenience. The estate must be preserved to prevent alienation. Thirdly, irreparable injury. It is not protected, the minor's inheritance may vanish. If the will fails, Section 8 of the Hindu Succession Act 1955 must apply. If the appellant being minor children are class 1 heirs and cannot be disinherited to a tainted document. If the court is satisfied with all these issues, the counsel will allow to move toward the prayer. Prayer. In light of the issue raised, argument advanced and authority seated, it is most humbly and respectfully pray this Honorable Court may be pleased. First, declare the purported will 21 March 2025 as null, void and legally unproved. Second, grant protection of the estate pending the final disposal of the trial to ensure the interest of the minor heirs. 3. Pass any other order that this court deems fit in interest of justice. And for this act of kindness, the appellant shall, as in duty, bound every pay.
Registered will deed executed by deceased, whether it is registered or unregistered document.
Registered document.
When it has been registered,
21st March 2025.
the document does not show that it is registered. Are you aware about the provisions of registration?
Can you repeat?
Whether you are aware about registration?
Pardon for the ignorance of the knowledge.
Whether you want interim relief? Are you aware about the provisions of interim relief? No?
So, pardon, sir.
Okay.
Thank you.
ठीक.
Council seeks permission to submit the compendiums. May it please Honorable Court, I appear on behalf of the defendant, Mr. Prisha Singhal. Shall I start with the argument? Thank you. The first one, the purported will dated 21 March 2025 has been validately executed compliance with the section 63 of the Indian Succession Act 1925. Defendant humbly submits that the purported will has been validly executed in accordance with the section 63 of Indian Succession Act 1925 and stand duly proved under section 68 and 67 of the Indian Evidence Act. The will bears the tester's signature and it attested by two competent witnesses, one of whom has been examined. The defendant has thus discharged the initial burden of proof. And in the absence of any legal sustainable suspicious circumstance, the plaintiff challenge is misconceived and liable to be rejected. The defendant complies with the section 63 of Indian Succession Act, which is execution of unprivileged will. Tester's signature, the will bear the signature of Sanjeev Khanna, executed at Aravali City, presence of a witness. The document was signed in the presence of two attesting witnesses, which is Shruti Malhotra and Amit Mehta. Affirming of execution, in her affidavit, the attesting witness Shruti Malhotra confirmed she was present at the residence in Mr. Khanna. Proof under section 68 to 71, the Indian Evidence Act. The defendant asserts that the execution can be proven even if the witness recollects are not perfect as per the exhibition legal principle. Fulfillment of section 68, the defendant has produced at least one attesting witness, Shruti Malhotra, who has affirmed the execution of the will. Section 63 says that will shall be attested by two or more witnesses. While Malhotra stated cannot confirm if the witness signed in his presence due to leaving shortly before completion. This does not invalidate the will. Under section 71, if the attesting witness denies or does not recollect the execution, its execution may be proved by other evidence. Section 71, which is meant to lead assistance and come to the rescue a party who had done his best but driven to a state of helplessness and impossibility, cannot be left down without any other means of the proving due execution. The will is not invalidate just because the witness cannot remember everything, every detail. While section 68 requires at least one witness to be called, if the witness fails to prove execution due to lack of memory or denial, the wills can still be saved using section 71 under Janki Narayan Bohir versus Narayan Namod Kadam case. The will settled that section 71 operates as a rule caution, not of execution, and prevents a duly executed will from filing a merely due to lapse in human memory of the reculant of the witness. In the light of settled legal position, the purported will has been validly executed in accordance with the section 63 Indian Succession Act. Counsel seek permission to second argument. Whether the plaintiff have discharged or can discharge the onus of proving that purported will is forged, fabricated, or caused by fraud, undue influence. The defendant humbly submits that the allegation of forgery, fabrication, fraud, and undue influence leveled against the purported will 21 March are wholly misconvenience and unsustainable and based on mere suspension. It is settled provision of the law that once the propounder proves due execution and attestation of the will in accordance with the statutory requirement, the burden squarely shifts upon the person alleging forgery or undue influence to establish the same. Sorry, I can't hear.
It is already proved beyond the doubt. The execution of that document?
The execution of document is proved, ma'am.
It is already proved.
It is proved.
Proceed.
In Venkateshala Iyer versus B. Tinnam Jamma, the Honorable Supreme Court authoritatively held that once the proponder proves the execution and attestation of a will accordance with the law, the initial burden stand discharged and the onus thereafter shifts to person alleging fraud. The, given settled legal position and the absence of the cogent, reliable or affirmative evidence, it is respectfully submitted that the plaintiff have failed to discharge heavy burden of proving that the purported will is forged, fabricated or validated by fraud, undue influence. Mere suspicion, alleged unnatural disposition or sustained family relation cannot invalidate a duly execution will, or nor can they attract criminal liability under section 467 of IPC, which is forgery of a valuable security will. Consequently, no grounds existing for directing a concurrent criminal investigation, and this issue deserves to be unanswered, answered entirely in favor of defendant. I would like to call my co-counsel for the next issues. Thank you.
Lordship, Counsel seeks permission, issue number 3 with argument, proceed with argument. Much obliged, Lordship. Third issue is that sealed, covered and confidentiality and NDA. That is, before going to third issue, Lordship, I made application before Honorable Court. That is, my will deed is confidential and assets of list be confidential. The Honorable Court has allowed my application and permitted the my will deed is confidentiality. So my submission is that for issue number 3, the defendant humbly submit that the court has fully empowered both inherent jurisdiction and settled civil procedure to regulate manner and sensitive document such alleged will, that is will is alleged and asset lists are placed on record. That's made application and Honorable Court has permitted to keep confidentiality of will deed. So to prevent prejudice, protect privacy and ensure the fair trial and media sensitive.
Where the trust is situated?
Yes, sir. Before
Where it is situated?
trust not on record, but Lordship before will deed before death of the Sanju Khanna made trust, that is legal heirs, divorced wife Kajal Khanna, that is 2 children. They have made for 2 children legal heirs trust. That's why not any shares in the said will deed.
Proceed.
Much obliged, Lordship. For third issue, one of the case laws, Naresh Mizrajkar versus State of Maharashtra. In this case, Supreme Court held that principle of open justice is subject to exception and court has made lawfully restricted public access or disclosure when required in the interest of justice and fair trial and administration of justice. Lordship, my humble submission that for third issues, for the my privacy and ensure the fair trial, that's why my made application for keep confidential my will deed. So my humble submission is that Lordship does not violate the principle of open justice or preface access of parties preserved under control according to challenge of the sealed covered procedure is unsustainable. Lordship, proceed with issue number 4. Much obliged, Lordship. Issue number 4 is that interim relief, freezing or preservation of asset, that is CPC, interim relief CPC order 39 CPC rule 1 and 2 said that interim relief. Lordship, my humble submission that defendant humbly submit that injunction under order 39 CPC does not entitle to plaintiff because, sir, when we granting the injunction, there are three provision are satisfied, that is balance of convenience, irreparable loss and prima facie case. There is no prima facie case to plaintiff. That is humble submission that plaintiff challenge only rest of mere allegation and forgery and suspicious and cogent prima facie case. No any strong proof of the plaintiff show that it is forgery and allegation made. So that is no any prima facie case. Second is that balance of convenience lies in favor of defendant because of lordship granting freezing order or appointing receiver cause grave injury to me because sir my ongoing business huge business in my huge business and investment contractual obligation part of the state. Lordship, my humble submission that balance of convenience lies in favor of defendant and no irreparable cause to plaintiff because of lordship. There is no solid proof that the defendant trying to secret sale, transfer or hide to right. There is no any evidence before this honorable court that transferring the defendant transfer the property or hide the assets of list. There is no any evidence before. So humble my submission that issue 4.
That will be decided by court.
Yes, sir. Much obliged, lordship. Issue number 5 is that presentation of minor and next friend as guardianship. The defendant humbly submit that representation of minor plaintiff by their mother Kajal Khanna as a next friend either automatically or unconditional under Rule 32 of the CPC. While the natural guardian ordinarily may act as a next friend without formal appointment of court, such entitlement be expressed subject to absence of any conflict in interest of the minor. In this case, particular lordship, in this case, sir, Kajal personally and litigant interests are clearly with these minor children. That is, lordship, Kajal is also personally and legitimately liable, so potentially adverse to minor plaintiff. Therefore, the attracting the disqualification and supervision safeguarding contemplated under 32 of the Rule 4 and 9 of the CPC. Sir, lordship, I would like to refer my companion.
We already have it.
Yes, my lord. I will refer my page number 5 of compendium, order 32 and rule 9 what shows, sir, removal of next friend. Where the interest of the next friend of the minor is adverse, that is Kajal Khanna is interest is adverse to minor, that is Kajal Khanna not entitled to act as a next friend. It is my humble submission. And my furthermore submission for the issue number 5, I would like to refer my memorial page number 18, that is one of the case Nagaya versus Chaudamma. In this case held that decree passed where the minor is not properly represent is voidable and court must ensure real effective and conflict free representation. So my humble submission that decree against the minor passed without proper and conflict free representation. Here in particular, sir, Kajal Khanna is adversely interested in the property. So sir, this is my humble submission for 6th issue. Present case next friend interests are potentially adverse. The court has duly bound to intervene to protect the minor welfare. Honorable court ought therefore to remove the present next friend and appoint independent guardian ad interim to ensure the conflict-free representation.
Kajal Khanna is mother. Mother of these 2 children.
Sorry, my
How
lord.
her interest is adverse to the children?
She is the mother of these 2.
Yes, my lordship.
Right?
Yes.
Then how she will be adverse?
She already divorced. She
is divorcee.
yes.
Divorce, that
Yes.
is a different thing.
Yes, sir.
But you are talking about the adverse interest. So how adverse interest is there of mother?
In present case, sir, Kajal Khanna personally and litigation interests are clearly intervened with and potentially adverse, my lordship. that is about his 30,000 crore estate, my lordship, Sanju Khanna. She also claimed that
She need to protect her children's future.
yes, my lordship.
That is
Not
valid
protect,
interest.
not protect. She also claimed that one of my shares in the property. That is adverse in present case, sir, and potentially also liability. So my humble submission is that Kajal is not act with next guardian, next friend.
And if the natural mother is present, who will be the next guardian of the minors? In the absence of the mother, we can understand.
Yes.
But if the mother is present, then who is the next guardian of the
But
minors?
she can file the suit. But my learned counsel in that memorial held that she also claimed the property shares. So that one is that adversely interest of the Kajal. That's my humble submission. She can file the next as a next friend for the guardian protection of minor. But she also claimed that the Maya also one of the interest. She also already divorced in 2018.
So in 2018, she got the property. She interest. 2018, she got the
Yes, sir.
maintenance. Do you have any record?
Made trust of the made trust for minor that their heirs and Kajal made already Sanju Khanna trusts. My lord.
She was also legally wedded wife of Sanjeev Khanna earlier,
Yeah, yes.
right?
Yes, lordship.
Before divorce.
Yes, lordship.
So at the time of divorce, whether she got the maintenance from Sanjeev,
Yes, lordship. My maintenance already paid, and made also her name is trust deed. Trust also made. I would like to refer my lordship in will deed.
her name is also mentioned in the trust.
Yes, my lordship.
Is it? Are you sure?
Sorry, my lordship. For minor children, made trust. So sorry, my lordship. So my humble submission is that she claiming the also shares in the in property. So it is Kajal also
Come
interest.
to the prayer clause directly.
Lordship, issue number proceeded last.
No, I guess your time is over.
Only.
Time
only.
is over. Time is already over. You come to the prayer clause directly.
Yes, my player lordship declared that the will is validly and legally executed. Second player is that recognize defendant one and sole executor or sole beneficiary. Third issue is that dismiss the plaintiff petition, and fourth issue is that uphold the seal cover confidential order, and fifth issue is that reject the prayer of the interim injunction, and the sixth issue is that pass any other order deemed the fit interest of the justice. Much obliged, Lord.
Do you have any points to rebuke?
Whether you want to reply, any ambiguity is there? Whether you want
Any
to
submission from your
clarify-
side?
नाही
त्यांनी नाही द्यायचंय.
तिने आर्ग्युमेंट जे केलेली अगदी क्लिअर आहे.
नाही सर
कुठं
I
ambiguity
have-
राहिली?
तुम्हाला काही त्याच्यावर ऑब्जेक्शन आहे का जे
आहे.
त्यांनी बोलले?
दोन
हां,
objections
मग
आहे.
बोला ते बोला ते
First,
सांगा.
they says that ki court cannot grant
If you are
temporary
comfortable
injunction.
in Marathi, tell Marathi.
नाही.
हां.
They cannot grant, court cannot grant temporary injunction. First, sir, according to section 151 of Civil Procedure Code, court have inherent power to grant injunction or pass an order
No, my
on the
lordship.
ground of end of justice.
Okay, what is second point?
Sir, second point, they claims that the private interest of the Kajal Khanna. There is no private interest of Kajal Khanna. The children comes under section 8 of the Hindu Succession Act, class 1 heirs, and they are entitled to property and succession of his father.
Lordship, how to grant injunction in
They are not permitted.
Reply to reply.
Counsel seek permission for rebuttal. Just two questions, sir. For granting injunction, there are three settled positions are proved prima facie case, irreparable loss, and balance of conviction.
Already you have stated that thing.
My humble submitted plaintiff are not clean hand, come with clean hand. That rejection of interim injunction.
Thank you.
Thanks.
Thank you.
इधर अटेंड करना है, स्टॉप करना है इधर।
अच्छा
ठीक, चलिए। यही रख देना।